are delighted to bring you some breaking landlord news, and I'm joined by David Smith, solicitor and also policy director for the Residential Landlords Association. And David, we've had the McDonald versus McDonald verdict now, and it's a landmark one for landlords. Could you tell us what it was all about and what the outcome is?
Sure, it's pretty complex, so I'll try and skip the boring legal bits, but the short position is it's about Section 21 notices, which of course most landlords use to ask their tenants to leave at the end of a tenancy, and whether or not Section 21 notices were covered by Article 8 of the European Convention on Human Rights and the Human Rights Act, and therefore whether courts were allowed to refuse to give permission to evict and give a possession order to a landlord where a tenant could raise an Article 8 defence. So Article 8 already existed where the landlord was a social landlord, but it hadn't been brought into the private landlord sphere at all. What the Supreme Court has decided is that Article 8 does apply to private sector landlords, but Parliament has already dealt with the matter, and Parliament has set out a process by which possession can be recovered through Section 21, and indeed it has altered it recently with the changes in the Deregulation Act and things like that, and therefore in doing so, Parliament has satisfied the requirements of the Human Rights Act, and so there is nothing further for courts to do. So from a landlord's perspective, it's actually a no-change situation, but there was a real risk that things could have changed dramatically, and Section 21 could have been massively undermined as a situation.
So could the tenant have played the human rights card? Is that kind of what it was about?
Yes, the real risk was that in every case, tenants would raise a human rights argument. Landlords would also respond with a human rights argument because landlords have human rights in relation to their properties as well. And it would have been potentially that, as the Supreme Court said, it would raise the potentially ridiculous situation that every single landlord and tenant possession action had the potential to be appealed to the European Court of Human Rights in Strasbourg, which would have made things quite pricey for everybody and extremely long. So we've avoided such a mad situation. And it's a real victory, I think, for sensible decision-making from the Supreme Court.
Fantastic. Well, thank you very much for bringing us that important news update. Thank you, David.